This Honorable Court of Appeals of Tennessee is now in session.
Good afternoon. Before we call the case, just a comment or two. If we should have any technology problems, don't worry about it. Just take a deep breath and pause and make sure we're all aware of it. And our experts will work us through and get us back on. We don't anticipate any, but sometimes they happen. Call the case, please, Mr. Hibner.
Karla Chase versus Ober Gatlinburg, Inc.
We'll hear from the appellant.
Your Honor, I would like to reserve 4 minutes for rebuttal.
Yes, that'll be fine.
Thank you. And may it please the court. This is a bit of an unusual appeal, I think. Certainly, it's not every day that a jury returns a defense verdict and then chastises the defendant for not taking the safety precautions that plaintiff claimed throughout the trial would have prevented her injuries. So what we have here, I think, is a rare instance of jury nullification. And by that I mean the jury was properly instructed on the law of negligence, but it chose to disregard the law in favor of giving defendant some sort of warning and, frankly, get out of jail free card. So in this case, I think it should be clear that the jury failed of its oath. It failed of its oath by essentially finding negligence and then absolving the defendant of that negligence. The facts begin on February 4th, 2011. Karla Chase, on that date, was severely injured while snowboarding at Ober Gatlinburg. Chase was an advanced skier and snowboarder. She regularly went to Ober Gatlinburg. In fact, she was even depicted in some of the promotional brochures that Ober has throughout the East Tennessee area. The accident happened when an unexperienced skier abruptly cut in front of Chase as she was descending the final bend of a slope called Ober Chute. Ober Chute is like a blue rated trail. It's classified as difficult, but of course it's not a black diamond, but it's sort of an intermediate level slope. In any event, to avoid colliding with the skier, Chase went to the ground and in a slide, which is a technique that experienced skiers are very familiar with. But here, because of the position of her snowboard vis-a-vis this other skier, she was forced to go down frontways or forward rather than backwards to avoid the collision. And in the process, she hit the ground and slid some distance to the edge of the trail, where defendant had erected at least 5 4x4 wooden posts. And I mean, these are the sharp, edge 4x4s, just like you'd get at Home Depot, and they're cemented into the ground. They're permanent. In fact, I read earlier today in Appellee's brief that they'd been there since 1984. But this is what they look like. And it's Exhibit 19 has a pretty good picture of it. And what you'll see when you're looking at Exhibit 19 is downslope. So we're looking down the slope, and there's a bend here. And you got your 5 posts with this plastic netting or fencing there. But only the uphill first post that the skier or snowboarder would come to is padded. And it's got this 2-inch thick protective padding wrapped around it. But the other posts there are not padded. And of course, that's it was one of the unpadded posts that Ms. Chase went face first into, making contact with that sharp edge, as you can see here in Exhibit 20. So she's sliding to avoid this other skier. She goes down in an anticipated way, and she heads for this off on the edge of the trail fencing, which is unpadded, and clearly she's severely injured. Now, we all know that there's inherent risks in skiing. Snowboarders, skiers lose control and crash into things on the edge of the ski trail. I mean, for goodness sake, these are permanently affixed there on the very edge of the trail. And I know it's hard to see in Exhibit 19, but there are lines drawn by the witnesses that show where the edge of the skiable terrain ends, which is just right there. And so both parties had experts, ski experts, and plaintiff's ski expert testified that, if you're going to have a structure like this at the very edge of the trail, and you're going to be padding at least one of these posts, you got to pad them all, because clearly by padding that post, it indicates that they knew that there was a risk of contact being made with an out of control skier. And there's no reason why you would not pad all of them, simply for the fact that there's no way to predict which post your skier or snowboarder is going to come into contact with. And even the defendant's own expert, Mark Petrozzi, testified that the studies show that out of all the people that get injured at ski resorts, by and large, they're injured by fixed objects just like these on the edge of the trail. So the reality or the risk to be perceived here, I think, is pretty obvious. Everyone knows that skiers can go out of control. Ober knows this. And there's no real decision-making or choice as to what they impact. And so they simply all have to be padded. And in fact, our expert testified that given the slope of the terrain here, it was more likely that she would have impacted one of these, which she did, one of these unpadded posts versus the uphill padded posts. And of course, the jury correctly seized on the negligence here. They really did. They said, according to the jury's unified pre and post verdict statements to the defendant, while they declined to find the defendant, as they called it, guilty, they said that they were in one accord, quote, that Ober in the ski industry should look into using materials for posts with rounded corners or more padding. So quite clearly, the jury has homed in on the negligence that we sought to prove. They just decided we're not going to hold Ober Gatlinburg liable in this instance.
Well, counsel, I mean, the jury answered the first question on the verdict form, didn't they?
Yes, they did.
And didn't it ask whether or not they found the defendant at fault?
Yeah, it sure did. But they also
they found no. Is that correct on the verdict form?
Well, they certainly did on the jury verdict form, but that comment is incompatible. And they asked to make the comment before they rendered the verdict. I've always been curious to know, what they were planning to do if the court had said, or the parties had said, no, you cannot make a comment. But in this instance, nobody objected. We allowed the jury to make its comment, and they come out and they say, not at fault. And then, of course, that's just the first question. That's the first thing that they have to decide. So they pretermitted the issue of comparative fault or anything else, even though they're sitting here telling us, hey, Ober Gatlinburg needs to do something about this, but not this time. Okay. And frankly, not only does the jury home in here on what we sought to prove, but they also usurp the trial court when they say you're not guilty, or when they say, in other words, we find that you should have done something differently, but we're not going to hold you liable. That's essentially like saying we find that you didn't have a duty of care. Okay. And that, as we know, is a question for the court and not the jury. Now, defendant, I think that in terms of the proof here, the jury's verdict, no fault, it is quite contrary to the evidence. You can look at the pictures, the testimony, and then, of course, the jury's own comment. But in addition to that, you've got all of these shifting, inconsistent positions of the defendant as to why this uphill post was padded, but the other ones weren't. First they say that none of the posts were padded, and all this was introduced through the testimony of their representative. And then they say we put hay bales there to protect out of control skiers. Well, then they realized that we actually had a photograph. Okay, and of course there are no hay bales here. So I think it was clear to the jury that this is certainly a risk that is foreseeable. There's no question about it. Even the defendant's expert would have to concede that it's a foreseeable risk. But what defendant finally settled on when it got to trial, sort of marrying its inconsistent positions, was that, hey, we're not required under industry standards to pad anything. Okay, but this is a case of ordinary negligence, all right? Sometimes industry standards can be helpful to a determination of whether there was a breach of the standard of care. But in this instance, there are no industry standards. There's just their position that, hey, we don't have to pad. Now, this leads me to our first evidentiary problem. And that is, during trial, we were ambushed by photographs of another ski resort, 3 other ski resorts, one out in New Mexico, one in Minnesota, and one in, I think, Virginia, where this expert comes in with these photographs that we had never seen before, that were only produced at the 11th hour after motions in limine were decided. Clearly not a seasonable production under Rule 26.051.
Mr. Collins, didn't they let you know, I don't know, a year, maybe more before then, who their expert was, what he would be relying on, what he would be saying, and you all elected not to depose him, correct?
We elected not to depose him, but these photographs were not produced. I mean, or what he was going to say about these photographs. And the problem here is that because they were sprung on us in this sort of nonchalant way in an email from a paralegal buried in there with dozens of other exhibits, you know, there was no way for us to either seek relief from the court in the terms of a continuance, and there was no way for us to question this witness successfully, because we don't know where the pictures are taken, what part of the slope they were taking on, if other parts of that same mountain were padded. So it really was, I think, on the level of gamesmanship, and it stung. Okay, and so the jury sees all of this, you know, 11th hour evidence that was never produced. Why wouldn't they just produce this ahead of time and say, we are supplementing our report? That's what the rules require. Okay, so we get this, we object, of course, and Judge Ogle really didn't give it much consideration. I think by that point of time, he was sort of, you know, ready to get this thing done. And the pictures came in, and then we get this comment from the jury. And I see I'm out of time. We ask that the court reverse and remand this case for trial.
You have your time for rebuttal. We'll hear from the appellee.
May it please the court, I'm Janet Hayes. I'm here today on behalf of Ober Gatlinburg, and opposing counsel has raised several issues that I want to address as time allows, but I think there is a threshold issue the court needs to take up before getting to those issues, and it's whether this appeal should be dismissed, since as we sit here, no party has been substituted as the plaintiff, and the plaintiff in this case is actually deceased. And I would like to walk through under Rule 25 of the Tennessee Rules of Civil Procedure. It's very clear that when a party dies, upon filing a notification of the death, that any interested party has 90 days to be substituted as the appropriate party. In this case, the plaintiff died. The case stayed in the trial court for 179 days. And during that time, no one made any effort to be substituted as the party plaintiff. Under case law interpreting Rule 25, if you look at Dobbins versus Green, it says that when no party makes an effort to be substituted, 90 days has lapsed. The case is dismissed and the claims are abated. And the case specifically says the claims are abated and cannot be revived by any other means, including other rules. If you look at Williams versus Williams, it says that when a claim is abated, that the claim is destroyed, quashed, and ended. So 90 days after filing, when no one made an attempt to be substituted as the party plaintiff, this case disappeared. It was abated. It ended.
Ms. Hayes, in
Yes.
this case, though, is the difference not that we have more than a claim, we have a judgment in this case? And so does that not make it fall under Rule 19 of the Rules of Appellate Procedure?
I think that's a great question, and I'd like to address that. Rule 19 has an appropriate place. Rule 19 provides that if a party dies after a judgment, but before or after an order, the word is order. If a party dies after the order, but before the filing of a notice of appeal, then substitution can happen in the appellate court. And that makes sense because there's 90 days for filing substitution, but only 30 days for filing a notice of appeal. Obviously, Rule 19 contemplates a scenario where the party dies after entry of the order being appealed from. In this case, the order being appealed from is the order on the post-trial motions. That the plaintiff did not die after entry of that order. The plaintiff died well before that.
some words to Rule 19 that are not there. But I understand the point that you're making, but Rule 19 itself does not say that. As I understand it, the applicable part of Rule 19 says that if a party entitled to appeal shall die before filing a notice of appeal, notice of appeal shall be filed and served by the deceased party's personal representative, or if there's not one, by the lawyer. Would it not just follow under that language, which is actually pretty broad in terms of dealing with when someone's entitled to file an appeal, but they die before the notice of appeal is filed?
I think if you look at the entirety of Rule 19, I think it actually says if the party dies after entry of judgment or order in the trial court, but before the notice of appeal is filed. Which would lead me to say, what is the applicable order or judgment in the trial court? To read it otherwise would be to say that it doesn't matter how long the case exists in the trial court. Rule 19 is always going to give someone an opportunity to appeal. So, for example, in this case, if you accept the appeal under Rule 19, it completely corrupts Rule 25, or Rule 25 serves no real purpose.
But that part of the rule that you're looking at deals with if a party against whom an appeal may be taken dies after entry of a judgment or order. And I guess my point is, I don't know that that's the section of the rule that applies, because it's not the party against whom an appeal is being taken, it's the party appealing.
Well,
anyway, I don't mean to beat this one to death, but
no, it certainly presents an interesting question. As I'm sure you're aware, there's no applicable case law addressing this factual scenario. But I think to interpret Rule 19 to allow this appeal is to completely corrupt Rule 25, and to say someone can sit indefinitely in the trial court and not do what Rule 25 requires, and then still preserve all their opportunities simply by filing a notice of appeal. So we would submit that as a threshold issue and think this appeal should be dismissed under Rule 25. And I think Rule 19 can comport with Rule 25. It's certainly Rule 19 serves a purpose. It's just not applicable in this particular case under these facts. Now, I want to obviously address the other issues that counsel has raised. He's raised an issue of jury misconduct, and we completely disagree that there was any jury misconduct. As has already been pointed out on the verdict form, the jury very clearly found Ober Gatlinburg not guilty. In addition to that, this statement that so much issue has been made of, the first thing that the jury said in this statement is, "We find defendant not guilty." Again, reiterating their position that Ober Gatlinburg was not guilty. It was only after they said that they went on to suggest that Ober Gatlinburg and the ski industry, quote, look into other matters. That is not tantamount to a finding of negligence or tantamount to a finding of guilt. I think there's a broad leap between this suggestion that they look into something and saying that the jury nullified its verdict or that it somehow found Ober Gatlinburg guilty. That is not at all what happened.
Counsel, I'm sorry, let me interrupt.
Sure.
Were the jury instructions, if anything, did they say about industry standards?
In the jury instructions themselves,
Yes.
I'm sorry, Your Honor, I can't speak to the specifics of the jury instructions. That I don't know that that's in the record.
All right.
I would analogize this situation to if you think of a professor grading a college exam or a college paper. The professor may give the student an A+ on the paper, but in the body of the paper write comments or write suggestions on other things the student may do. The writing of the comments or the making a suggestion on how to improve something in the future is not tantamount to failing the student. You can still get an A. You can still be doing a good job and not be negligent, and the jury make a suggestion. So I think
do you agree or disagree that an industry standard, in this case, the ski industry standard, may or may not set the standard for as far as determining whether there's a breach of care? I'm sorry, go ahead.
No, I was trying to clarify your question. Are you asking if the industry standard is applicable or relevant to
not just whether it's applicable or relevant, whether it actually sets the standard of care, necessarily sets the standard of care.
Well, certainly in the trial in this case, what was being done in the industry was evidence that the jury considered, and that formed their conclusion. Which the idea of industry standards, I think, overlaps into another issue that's been argued, that was raised in the briefs and has been argued here, which is the idea of photographs not being timely disclosed. And we completely disagree with that, and actually are shocked by the suggestion that photographs were not timely disclosed. As has been noted, Ober Gatlinburg had an expert. The expert was disclosed, and the expert's report was provided some 4 years before the trial of this case. And in that report, the expert said that he would look to and talk about what other ski areas did. As has been mentioned, that expert was not disclosed, or I'm sorry, was not deposed by the plaintiff, was disclosed 4 years before trial. Then Ober Gatlinburg complied with all the scheduling orders, all the rules governing disclosures. Ober Gatlinburg submitted an exhibit list that identified specifically these photographs. There was no phone call, question, or request to see the photographs. Ober Gatlinburg's counsel reached out on multiple occasions and tried to set up meetings to exchange exhibits. And when those efforts failed, Ober Gatlinburg sent them by email, which is exactly how plaintiff's counsel disclosed their exhibits. And at the same time, those were all sent. Everything was in compliance with all the rules, with all the scheduling orders. And counsel, if counsel was not on notice, it certainly was not the fault of Ober Gatlinburg. So there was no trial by ambush. Another issue that was raised in the briefs, there's an issue raised about the plaintiff claims that there was an error in the introduction of some medical records. And let me say it is accurate that the trial court put down an order saying that there should be no reference to IV drug use. And when a stack of medical records was published to the jury, and this is included in the brief, there was one record with a very small handwritten notation that said IV drug use. And that did get published to the jury. However, I feel very strongly that was not any type of harmful error. It was absolutely a harmless error.
Ms. Hayes, just
Yes.
to clarify, it was admissible that the plaintiff had used drugs, and what I think, is there evidence that she was under the influence at the time of the accident?
It
Or
was,
no?
yes, it was admissible that the plaintiff was a drug user, and it was admitted that there were drugs in her system at the time of the accident.
So it
The
was
trial
just
court
the
had
fact
asked,
of IV drug use that wasn't supposed to come in. Okay.
it was the mention of IV drug use. And that is, your question is important because it goes to the issue of whether this was a harmless error. First of all, I'd like to note it's the plaintiff's burden to prove that the error was prejudicial. Case law says the plaintiff, or the one claiming the prejudicial error, has to prove more probably than not that the error prejudiced the jury in its verdict and unfairly tainted the decision-making process. In this case, there's absolutely no evidence in the record that the introduction of this record tainted the decision-making process. In fact, there is no evidence in the record that any juror actually saw this record. The reality is a stack of records was handed to the jury. When the mistake was noticed, this record was pulled out. These records did not go into the jury room during deliberations. They were not orally mentioned during opening, during closing, during any direct or cross-examination testimony. There was no verbal reference to these. If you look at applicable case law regarding harmless errors, it says the fact that an error was already established by other evidence suggests that it's harmless. And so to your question, yes, the fact that she had drugs in her system was established by a doctor, Dr. Taylor, that she relied upon. Her mother testified that she had a drug problem and testified regarding her prior drug use. So the jury already knew that information. Also, it's harmless error if the error was, quote, unlikely or likely unnoticed in the minds of the jury. And again, we're not sure that any juror was even aware that this note was in this record that was passed around the jury box. Certainly, it would suggest that it was unnoticed. Nothing drew attention to it. There were no statements, no arguments about this particular error. This case has been going on for a very, very long time. The plaintiff died some time ago. As we sit here today, we don't know who the plaintiff is. No one has been substituted. The plaintiff got a fair trial. She received her day in front of a jury. It is the jury's role to evaluate whether there was negligence or not. And the jury was very clear. They were very clear on the verdict form. There was no negligence. And even in this oral statement that so much issue has been made about, they reiterated that the defendant was not guilty. There is ample evidence in the record that supports the jury's finding. As has been mentioned, she was an experienced snowboarder. She was familiar with this slope. She was familiar with the skier's responsibility code, which requires that a skier remain under control at all times. She knew the inherent risks associated with skiing, and yet she found herself out of control and off the skiable surface of the slope. And it was there that she hit netting and a post. And there was plenty of evidence in front of the jury that the netting and the post that were used were reasonable for the area where they were used and were reasonable and in conformity with what other ski areas utilized. Under these facts, I think it's safe to say the plaintiff had her day in court. She had a clean trial. The jury did what they are supposed to do, and they found Ober Gatlinburg not guilty. As I'm out of time, I would simply ask that you affirm the decision of the trial court. Thank you.
Thank you. We'll hear from the appellant in rebuttal. Mr. Collins, you need to unmute, I think.
Sorry about that.
That's all.
If it please the court, counsel began by saying that Rule 25 of the Rules of Procedure is at risk of being corrupted, but I submit that the only rule that is at risk of being corrupted is the rule that says that juries are supposed to follow the law as instructed by the court. And to your question, there was no instructions related to industry standards, not that I recall. Certainly, it was an ordinary negligence instruction. There was nothing wrong with the instruction. The jury just didn't want to follow it. Regarding this dispute over whether Trap 19 applies or Tennessee Rule of Procedure 25, I mean, it's Rule 4 of the Tennessee Rules of Appellate Procedure, which sets the clock for notice of appeal, which is jurisdictional, and it is Rule 4B, subpart 3, which extends the deadline for filing a notice of appeal until resolution of the motion for new trial. So we're under the rules of appellate procedure, not the rules of civil procedure in the trial court. And in fact, the other piece that seems to be overlooked by the defendant in this case is that, courts are by their nature reactive institutions. I mean, it's not an automated thing. In order for a court to dismiss a case under Rule 25, they have to make a finding. The trial court makes a finding that there is no excusable neglect. And if here, of course, if they had filed a motion to dismiss this case, we would have argued, hey, we're under Trap 19, not 25, and that's excusable neglect. But the court never made that determination because they didn't raise it. And
sorry. Under Rule 19, after notice of appeal is filed and served, substitution shall be effected in the appellate court in accordance with this subdivision. Have we ever had a substitution?
No, we haven't. And the reason we haven't is that they came out of the gate hot with a motion to dismiss. And this panel said we're going to have to brief this to determine whether or not we're going to proceed under 19 or 25. And so in our reply brief, I filed the necessary paperwork to show our letters of administration where Rebecca Ober, the mother, has been appointed administrator ad litem. for purposes of this appeal. But to fault plaintiff for not filing a motion for substitution when this court has said they're going to hear this argument, I just don't see how we get there. So the substitution is ready. They can't have any objection to it. And, you know, I submit the court should go ahead and make the substitution. It's got everything it needs to do it. And Rule 19 is met, and that's the substitution that needs to happen. Producing these photographs, which obviously swayed the jury into making a ultra vires decision about duty of care in industry standards, submitting those papers 4 years after an expert has submitted his report and just on the eve of trial is not good enough. That is not what is contemplated by the letter or spirit of 26.05, which says they have to supplement and they have to do it in a way that brings it to our attention. Because had they done that, we probably would have ended up with a trial continuance, or we would have had a more fulsome opportunity to get Judge Ober to strike these photographs, which I think he would have done if he realized really what they had done.
Mr. Collins, how long had this case been pending before it was tried?
Oh my goodness. I got in this case pretty late in the day. It's a 2011 injury, so 2012. I think is probably when it was filed.
7 or 8 years, probably.
Yes, and these are just produced on the eve of trial by a paralegal in an email with 50 some odd other exhibits. Thank you. We ask that the court reverse and remand for a new trial.
Thanks to counsel for both sides. We appreciate your argument this afternoon. Mr. Hebner, if you would please